Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2 in Jefferson County, Texas. Today, you have been asked to come to court for what is called an arraignment. And what the arraignment is basically an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. Now, the case that you have in this court is a criminal case. Criminal cases are divided into felonies or misdemeanors. The case that you have in this court is a misdemeanor case. Felony cases are normally referred to as your more serious type of criminal offenses, whereas your misdemeanor offenses are normally referred to as petty offense. Does not mean that they're not serious. It just means that they're not as serious as a felony case. And when I use the term serious, what I mean is I'm talking about the facts of the case and the range of punishment that a person can receive if they are convicted of the offense. Now, felony cases are divided into 5 categories, and we'll start at the top and work our way on down to the bottom. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and state jail felony. If a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail, and a fine that does not exceed $10,000. If a person is convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years, and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is a minimum of 5 years to a maximum of 99 years to life in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of the highest felony, which is a capital murder, the range of punishment is minimum life in the state penitentiary without the possibility of parole or death by lethal injection. Now, as I mentioned to you earlier, your case is a misdemeanor case, so you don't have to worry about that type of punishment. Now, misdemeanors are divided into 3 categories. We'll start at the top, work our way on to the bottom. You have the capital A misdemeanor, Class A misdemeanor, Class B misdemeanor, and the Class C misdemeanor. If a person is convicted of a Class C misdemeanor, the range of punishment is minimum fine only. And usually the fine cannot exceed $500. Now, excuse me. If a person is convicted of a Class B misdemeanor, the next highest misdemeanor, the range of punishment is minimum 0 days to a maximum of 180 days, which is 6 months in the county jail, or a fine that does not exceed $2,000, or you could be given both such fine and confinement. If a person is convicted of a Class A misdemeanor, which is the highest misdemeanor, the range of punishment is minimum 0 days to a maximum of 365 days, which is a year, in the county jail, a fine that does not exceed $4,000, or a person will be given both such fine and confinement. Now, as a defendant in a criminal case, you have rights. One of the rights that you have that we're going to go over first is your right to have an attorney. Now, the information on the clipboards that have been handed out mention or talks about your right to an attorney. First document that we're going to talk about on the clipboard is titled Judge's Explanation of Rights to Defendants Without Attorney. And it states, as a defendant as a criminal case, you have three options regarding your right to have an attorney. Number one, you may hire an attorney. Number two, if you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. Or number three, you may represent yourself. That means, basically, that means that you would have to waive or give up your right to an attorney to represent you. And then once you waive or give up your right for an attorney to represent you, then you can represent yourself. If you want an attorney to represent you and you have enough money to hire an attorney, your case will be reset. Reset means you'll be given another court date to give you time to hire your attorney. If you want an attorney to represent you, but you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. But you must first fill out a financial questionnaire. Now, the financial questionnaire is on the clipboard. It is titled Jefferson County Affidavit of Indigence. Now, you would have to fill out the first page of that document. It has your name, address, whether or not you're employed, and then they have financial information like your income and your bills on the first page. And on the second page, you will fill out half of that page, and basically you sign your name and your address, the county, which is Jefferson County, and then you will sign it. And then the bottom part of that second page, the court will fill that out. At that point, the court, once they review the case, the court will determine whether or not you qualify for court-appointed attorney. Now, if you want to waive your right to an attorney or give up your right to have an attorney and you want to represent yourself, you'll have the opportunity to talk to one of the two prosecutors that's in court. Prosecutors, they are assistant district attorneys that work for the Jefferson County District Attorney's Office. They are sitting in front of you at the table. You'll have the opportunity to talk to one of them after you fill out a waiver of your right to have an attorney. So you have to fill out the waiver first. Now, the waiver is the document on the clipboard that's titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. You will have to fill out that document if and only if you want to represent yourself. So if you do not want to represent yourself, you do not have to fill out that document. And I'll go over that document with those of you who will be waiving your right to an attorney and representing yourself. I'll go over that document with you in a few minutes. Now, you should be aware, Mr. Abar, the gentleman had his hand up in the back.
Document.
No, the document that I last mentioned was the waiver of right. It's the waiver of counsel for purposes of entering guilty plea or proceeding to trial. You only sign that read and sign that document if you will be representing yourself. If you will not be representing yourself, you don't need to worry about that document. So the document that I'm going over right now, I'm going to continue going over, is the judge's explanation of rights to defendants without attorney. And I'm getting ready to go over the second to the last paragraph that begins as follows. Be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, if you choose to waive your right to choose to proceed without an attorney or waive your right to an attorney, you want to represent yourself, You may change your mind at any time and may request counsel from the court. At the bottom of this document, it is titled Defendant's Choice. Mark initials next to only one choice. If your choice is, I want to reset my case to hire my own attorney, then you will place your initials on the first line to the left. If you have already hired an attorney to represent you in your case, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. If you want to apply for a court-appointed attorney, then you will place your initials on the third line to the left. If you have already been appointed a court-appointed attorney, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. Now, if you want to waive your right to an attorney, that is, if you would like to give up your right to have an attorney, you would like to represent yourself, then you will place your initials on the fifth line to the left. Once you have finished initialing one of the 5 lines, then you will sign your name on the line that is titled Defendant, and you will date it today's date, June 18th of 2024. Now, for those of you who will be waiving your right to an attorney or giving up your right to an attorney, and you would like to represent yourself, you have to read and sign the next document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. And it states as follows: I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily, which means that you're doing this of your own free will. Nobody's forcing you to do it. And intelligently, meaning that you know what you're doing. So my waiver is voluntarily and intelligently made. Furthermore, I have been advised this 18th day of June 2024 by the County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I'm unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge, if I am not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. If that is your choice, then you will sign your name on the line that is titled Defendant, and you would date it today's date, June 18th of 2024. Now, as a defendant in a criminal case, you also have a right to have a trial by jury. The 12 chairs that's behind the bailiff, we call that the jury box. 6 citizens from Jefferson County will be selected to serve as jurors on your case. They will listen to all of the evidence. They will listen to the oral arguments of the counsels. They will deliberate, and then they will decide to find you either not guilty or guilty of your charge. You also have a right to waive or give up your right to have a trial by jury. Now, if you waive or give up the right to have a trial by jury, your case will come before the court or before the judge in one of 3 ways. One way it can come before the judge is by way of a trial. We call that a bench trial. It's a trial by judge only. The judge will be the judge and the jury in the case. The judge will listen to the evidence, listen to the arguments, and the judge will decide whether to find you either not guilty or guilty of your charge. The other way that your case can come before the judge is by way of a plea bargain. Now, It can come before the judge by way of an agreed plea bargain. What a plea bargain is? A plea bargain is an agreement that you have worked out with the district attorney's office to settle your case. We call that a plea bargain. Now, your case can come before, if you have an agreement, we call that an agreed plea bargain. If you're unable to reach an agreement with the district attorney's office to settle your case, and you still want your case to come before the judge, we call that an unagreed plea bargain. Now, if you've been unable to reach an agreement with the state of Texas to settle your case comes before the judge by way of an unagreed plea bargain. The judge will decide what your punishment will be in the case, within the punishment range, anywhere within the punishment range. And for example, if you have a class B misdemeanor, the range of punishment, minimum 0 days to maximum 180 days, you could be given a fine that does not exceed $2,000. So that's the range that the judge has to work with. Now, the judge could give you probation in the case as well. And we'll talk about probation in a few minutes. Now, if you and the state have reached a plea bargain agreement, your case will come before the judge. The judge can do one or two things. The judge can accept the plea bargain agreement or reject the plea bargain agreement. Now, if the judge rejects your plea bargain agreement, in essence, you and the state have worked out a plea bargain agreement. Let's say the state say, okay, judge, we're going to give this person 1 day in jail. That's just an example. And you've agreed to that. And the judge said, well, I'm not going to follow that. In essence, the judge rejecting it. Well, you can say, well, judge, since you're not following my plea bargain agreement, I take my plea back. I'm not going to plead guilty. I'm not going to plead no contest. And you can do that if the judge doesn't follow your plea bargain agreement. Now, if the judge does follow the plea bargain agreement, and within 30 days of the plea, of you disposing of this case, you decide that you would like to appeal your case. One, an appeal is you have a higher court looking at your case to decide whether or not you've been wrongfully convicted or whether or not this court committed an error by convicting you. That's what an appeal is. You would have to get permission from the judge in the court that followed the plea bargain agreement. You have to get permission from that judge so that you can appeal the case. The judge gives you permission. Then your case will leave this court and go to the Ninth Court of Appeals, which is right above this courtroom on the 3rd floor. They will review your case. Now, they can do one or two things. They can grant or deny your appeal. If they grant your appeal, they could just simply find you not guilty, or they could send the case back down to this court and order this court to give you a whole new trial. If they deny your appeal, then you can appeal it to a higher court than them. You could appeal it to the Texas Court of Criminal Appeals, which is located in Austin, Texas. You would have to file what is called a pro se petition for discretionary review. Now, what that means is this. Pro se means you are representing yourself, and you'll be petitioning the Texas Court of Criminal Appeals, which is the highest criminal court in the state of Texas. You'll be petitioning them to review your case to see, one, whether or not your appeal should have been granted, or two, whether or not this court wrongfully convicting you or committed an error by convicting you. The Texas Court of Criminal Appeals can do one of two things. They could grant or deny your pro se petition. If they grant your pro se petition, they can simply find you not guilty, or they can send the case back up to the Ninth Court of Appeals, or they can send it down to this court and ask this court to give you a new trial on your case. Now, or they can order this court to give you a new trial. Now, the other thing that they can do is if they deny your pro se petition, which means that they've denied your pro se petition, at that point, your conviction will stand. Now, I did mention that when the court or you and the state are talking about a plea bargain agreement, the court can either give you probation. There are two types of probation. One type is called unadjudicated probation. Unadjudicated probation. The other type of probation is called adjudicated probation. The difference between the two is as follows. Unadjudicated probation means that, one, you have not been adjudicated, therefore you don't have a conviction on your record. And if you successfully complete the probationary period, the case will be dismissed. It will not result in a conviction on your record, and you may qualify for a non-disclosure. What a non-disclosure is basically mean that your record could be sealed. What that means, the general public cannot have access to your criminal record on this case if you get a non-disclosure. Notice I said the general public. Now, the government can have access, but not the general public. You know, the police department, that's the government. And so other governmental agencies or departments, they can have access. But the general public, which is most of the public, cannot have access if you get a non-disclosure. Now, the other type of probation is called adjudicated probation. Adjudicated probation. Adjudicated probation means that you will have a conviction on your record when you get on probation. However, there's something that is called judicial clemency. What that means is the court or the judge can set your conviction aside if one of three things happen. One, you have to complete the probation. Two, there cannot be any more time left on the probation. And three, you have to be successfully discharged from the probation. If those three things happen, the court has the discretion to set aside your conviction. Now, if you get a subsequent conviction, that is, if you get another conviction later on, then this case that you got judicial clemency on can be brought back up. It can be revived, resurrected, or brought back up and used against you. And if you try to get a license with CPS, they can deny giving you a license, or if you have a license, they can revoke or suspend that license. Now, the other right that you have that I mentioned that you have a right to have an attorney. You have a right to have a trial by jury, or you can waive your right to have a trial by jury, have a bench trial, a trial by judge, or you can enter a plea, an unagreed plea bargain or an agreed plea bargain. The other right that you have is a right to have witnesses to come to court to testify. Witnesses can either testify for you or against you. If you're representing yourself, you can ask some questions. We call that, or if you're represented by an attorney, your attorney can ask some questions. We call that either direct examination or cross-examination. Now, you also have a right to waive or give up your right to have a trial to have witnesses to come to court. And if you waive or give up your right to have witnesses to come to court, that simply means that you will not be calling witnesses. It does not mean that the state will not be calling witnesses, because they will be calling witnesses. Now, you also have a Fifth Amendment right against self-incrimination. Fifth Amendment right against self-incrimination. I know most of us, maybe all of us, watch television, and we see these shows where somebody say, "Well, I take the Fifth." And what does he mean by that? I take the Fifth. I'm not saying that. Okay. And so your Fifth Amendment right against self-incrimination gives you the right to not testify against yourself in the case that you've been charged with. In essence, the state of Texas, the district attorney's office, the government cannot force you to take the witness stand if you exercise your Fifth Amendment right against self-incrimination. Now, you can waive or give up your Fifth Amendment right against self-incrimination. And if you waive or give up your Fifth Amendment right against self-incrimination, that means that you will be taking a witness stand. Okay. Now, you also have a right to have what we call discovery. That is, you have a right to see the evidence or discover the evidence that the state has or that the state will be using against you. That is, you have the right to see witness statements, your statement, police reports, lab reports, listen to audio recordings, see video recordings, uh, look at have access to any type of instruments that the state will be using against you uh, in your case, photos, etc. Now, you also have a right to waive or give up your right to have discovery. And by waiving or giving up your right to have discovery, that means that you will not be having access to the evidence that the state will be using against you. Now, everyone that's here today for arraignment, you've been arrested and you're out of jail. You're out of jail either on a cash bond, which means you paid the full amount of the bond to get out of jail, or you're out of jail on a surety bond, which means you paid a percentage of the bond to the bondsman to get out of jail, or you're out of jail on what we call a PR or personal recognizance bond, which means that you were released under your own personal recognizance with a promise to appear here in court. Now, every day that you have spent in jail, that jail time can be used as credit towards your punishment. So, for example, let's say you spent 5 days in jail. You and the state have reached a plea bargain agreement for you to serve 5 days in jail. That simply means that you would not have to serve any more time in jail because the 5 days that you spent in jail will be given to you as credit towards your punishment. So in essence, you'll be given what is called credit for time served. You've already served your time. Now, the time that you spent in jail can also be used as credit toward your fine and court costs. You receive $100 credit for every day that you spent in jail. That will go toward your fine and court costs. Now, I use the term every day. I didn't say 24 hours. So let's say you went in jail, you were arrested, you was booked in jail at 11:59 p.m. That is 1 minute before 12 o'clock on Friday, right? And you booked out of jail 2 minutes later, 12:01 a.m. Saturday. That's 2 days. You was in there 2 minutes, but you get 2 days credit because it's 2 different days, okay? And so the jail time that you get as well can be used toward your punishment. You get $100 per day toward every day that you've been in jail. And so if you spent 5 days in jail, that's $500. You and the state reached a plea bargain agreement for you to pay fine and court costs of $500. You will not have to pay because the 5 days that you spent in jail has already paid it off. Now, if the state is offering 7 days in jail and you spent 5 days in jail, that means you would have to pay, you have $500 taken from the $700, at least $200. Then you would have to pay $200. If you cannot pay the $200, no problem, because we can convert, we can put you on a payment plan where you could pay it off in monthly installments until it's paid. Now, let's say you don't have the income even to pay the money off on a payment plan, no problem. Why? Because we can convert your fine and court costs to community service, and you will receive $12.50 credit that will go toward your fine and court costs. So, for example, if you owe $200, that's 2 8-hour work days, okay, which is 16 hours, and then that'll pay off your fine and court costs. All right. Now, if you have not been in trouble before, you're here for the first time, and Jefferson County has a program that's called pretrial diversion. With the pretrial diversion program, for first-time offenders, they will dismiss your case and you can get it wiped off your record. And this is how it works. It has to be your first time getting in trouble. It cannot be an offense for unlawfully carrying or weapon or resisting arrest. And you have to have an attorney to assist you with filling out the application and submitting the application to the district attorney's office so that it's done properly. Now, if those things happen, you get into the program, the state will dismiss your case. You complete the program, you can get it expunged, which means wiped off, erased, or deleted from your criminal record, just like it never happened. Okay. Now, if you're interested in the program, just let us know, and we'll be able to direct you to the people that you need to talk to get into that program. Now, if you are a veteran of any one of the branches of the United States military, Jefferson County District Attorney's Office also has another program that is called Veterans Court. It's a program for veterans only. With that program, Uh, they will, once you get into the program and complete the program, your case will be dismissed. And you can qualify for what is called a non-disclosure. And I mentioned to you earlier what a non-disclosure was. It's basically where your record is sealed to the general public. Okay? So they have Veterans Court and they have the pretrial diversion program. Veterans Court is for veterans only. Pretrial diversion is for everyone, but it's for anyone, people who have first time getting into trouble. All right. Now this court, County Court Law Number 2, Jefferson County, Texas, has a program that is called the CSI programs. CSI stands for Community Safety Initiative. It is a program that I started within the first 100 days of taking office. The program is designed to address the issue of what we call recidivism. Recidivism means people committing crimes over and over. And so how do we address it? Well, we address it through our Community Safety Initiative. With the Community Safety Initiative, we have partnerships with agencies in the community. One agency that we have a partnership with is the Spindletop Center. Spindletop is our local mental health center in Southeast Texas. And what Spindletop will do, Spindletop will have a private interview, either in our conference room, at their facilities, or maybe you want to do it over the telephone with them, whatever is convenient for you. Then they will also do an assessment. In essence, determine, they can assess your mental health issues, and then they can develop a treatment plan to address your mental health issues. Treatment plan for either outpatient or inpatient services. Now, in order to participate or to qualify for the program, you do not have to be insane or incompetent. You can merely suffer from anxiety or depression or any host of mental illnesses. They have the expertise to address your mental health needs. If you have issues with drugs or alcohol, well, Spindletop has a program that is called ATAR. ATAR stands for Addiction Treatment and Recovery. Our local Drug and Alcohol Council has a program that is called OZAR. OZAR stands for Outreach, Screening, Assessment, and Referral. Both of those programs are drug treatment and alcohol treatment recovery programs. And what they will do is they will do a screening, an assessment, and they can develop a treatment plan for either outpatient or inpatient treatment, depending on what your needs are. If you are unemployed, or if you're looking for a better job, well, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, or the chemical industry. Once you are trained in one of the areas that you select, then they will assist you at getting a job in the area that you're trained in. Now, if you have not graduated from high school and you have not received your GED and you would like to obtain your GED, which is graduate equivalency diploma, CICE has a GED program. Now, all of these programs that I just mentioned are free. Does not cost you anything but time. And in this court, I like to say that we do not just give time, we take our time. That is, we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And we believe that if we produce productive people would not commit crimes. Why? Because they have too much time to lose. And so I always say that when you come to County Court at Law Number 2 in Jefferson County, Texas, we do not just have court as usual. We have unusual court. It's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before the court. And if we make a difference in their life, we will make a difference in their home. And if we make a difference in their home, we will make a difference in their community. And so, because what comes out of the home goes into the community. And so, all of these programs um, that I mentioned are free. It only means that you just have to take a little time. Now, the other thing about the program is this: all of these programs can be used as community service towards your punishment. So, for example, let's say you receive punishment to pay a fine, but you can't pay the fine, and we convert the fine to community service. And so, let's say you're addressing your mental health needs. 1 hour you're in counseling, uh, $12.50 will go toward payment of your fine and court costs, and 1 hour will go toward community. Well, let's say you're in the GED program, right? Every 1 hour you participate in that GED program, $12.50 goes toward payment of your fine and court costs, and 1 hour go toward your community service. Or let's say you're in job training, okay, at the CICE program. Every 1 hour that you're being trained to get a job, $12.50 goes toward payment of your fine and court costs, and 1 hour go toward community service while you're in the program. And so I tell people this all the time: you are not just killing two birds with one stone, you're killing three birds with one stone. You're in the program, you're getting community service hours, and you're paying your fine and court costs, all by doing one thing. Okay, so if you're interested in those programs, just let us know, and we'll be happy to assist you with getting into the program. Now, later on, we're going to have some individuals from Spindletop who is going to come before you and tell you a little bit more about their program. Now, before they come, what I need to do is tell you that the paperwork that you have on the clipboard, we're going to pick that paperwork up from you. If you need any assistance at filling out the paperwork, then we have our personnel here in the County Court at Law Number 2 who will be happy to assist you with filling out the paperwork. Okay. Now, it's going to take us a little time to pick up the paperwork from everybody and then to evaluate it. And then once we do that, we will call you up before the bench one at a time. Okay. And then when I say the bench, it's in front of the judge right here in front of the table. We're going to call you up one at a time. Now, as I mentioned earlier, it's going to take you a little time take us some time to evaluate and go over all of the paperwork. And so if you need to use the restroom, okay, if you need to use the restroom, then there are two restrooms right outside the courtroom in the hallway. In the hall, there's one in front of County Court at Law Number 3. That's the men's restroom next door. And we have the women's restroom on the opposite side of the hall in front of the 172nd District Court. Now, do not leave the courthouse, okay? Because if you leave the courthouse and if your name is called and you're not here to answer when your name is called, your bond can be forfeited, okay? You're out on bond. Your bond can be forfeited, and if your bond is forfeited, a warrant will be issued for your arrest. So do not leave the courthouse. Okay. So at this time, I'm going to take a break for a minute, give the folks on Spindletop an opportunity to come in. Okay, ladies and gentlemen, at this time, we will have folks from Spindletop. They're going to come forward and tell you a little bit more about the program that Spindletop has to offer. Okay,
Thank you, Ron.
you're welcome.
Good morning. My name is Steve Hinton. I'm a mental health deputy licensed by the state, commissioned here with the sheriff's office. I'm here with my coworkers, Chris and Chloe. Both these ladies are qualified mental health professionals from the state. The reason we are all here this morning in this courtroom is because we're registered by the Everett, which is the senior person who helps people advance. We just found there was statistics prove that those who have legal issues commonly have mental health needs, substance use disorders, but sometimes just lack of community resources to help you with a particular situation.
So the reason why I'm making things like anxiety, depression, I think we all deal with it at some point in our lives, right? There's obviously a host of other issues that we all can deal with as well, and that there is help for, but those ones we're primarily seeing. Doesn't mean that we all want to work with. There are really great community resources out there that are well funded, but they're not well advertised, and sometimes even just finding the money for one can be a bit like down the business. So that's where we come from.
Now, maybe this is your first time being in court today, maybe it's your 10th time being in court today. What we have to offer you here is hope. The ability to reach out is going to be very important, and Chris is going to tell you how you can do that very vital.
So over at Cambridge, Chloe over here, she handed out this form, right? She handed out to every single person. The reason she's handed to every single person is because it doesn't matter if you are here as an independent or as support. It doesn't matter if you need information for yourself or somebody you care about. We understand this is not a moment that anybody expects or can prepare for. And we understand that this moment brings up a lot of emotions, right? So we want to do what we can to make it productive, to help outside of here as well. So if there's anything you need, we want to make sure we can match it. This is built like a baseline of the The reason it is made this way is so you understand that any information you put on it is protected under state law, the same as your medical information. It will not be seen by anybody outside of me or Chloe. We're the only ones that will be contacting you. The only thing you're consenting to on this is one of us contacting you one time, in a matter of your choosing. So you have contact information. Now, if you contact us back, we'll match that. If you want to keep reaching out, we will keep working with you. We're not here to add stress at any time. We're gonna match your schedule. We're gonna match your response. We know you all work hard for yourself because you all showed up here today. I'm sure there's plenty of names on that docket that will call if they might walk in here. There's things that come up, life happens, but you all made it. So on this, you have a few different options for a county talk, right? Now, the number you will get will either go to me or Chloe. That number that you receive will be our work one. It's only gonna go to one of us. I think you're in room most of the calls, right? But if you have a preference, you can put it down. Now, that means that if you reach out, she's gonna be the only one that sees it, or if it's for my number, I'm gonna be the only one that sees it. If you need something, one of the biggest resources that we see, what we need for here is just support. If you need to talk about stuff, if you need to reach out, or you just need to just work for your thing, we're here. That's kind of why they do have mental health professionals in here, because we are good. Rather than good. So on the other side of that, there's the option to speak privately today. If you have something you know you need, or something you know you need to talk about, you can see a moment of grief. Maybe understand there's a lot of court process, it can be nerve-wracking, it can bring a lot of emotion. You have the option to step back there during the reset, and just take a breath, take a moment, take time. The only thing we're here to do is
I also have a flyer here that I want to get in everyone's hands today before you leave. On the back, it tells you some of the advantages of actually participating, but on the front, it also has a 1-800 number. Should you ever find yourself in an unsafe place, you can call that number and get help.
what's important about that number is it's the first resource we need. Now, you'll have our contacts, right? But whenever you fill out the sheet, you will automatically, one of us is gonna reach out to you. You'll have a contact for us. Outside of that, that number is a crisis hotline. It doesn't matter what time of day, it doesn't matter where you are. It is active almost statewide. You can call it at 6 a.m. on Christmas morning outside of the plan, and they would answer. I say almost statewide because I know there's some areas in Texas where no phone, unfortunately. But you can reach out to them at any time, and they will be there. Now, on the other side of that, and that's what the white area is, right? It does not matter where you're from. We understand that a lot of people come to court in Jefferson County, but there's nowhere close to here. We work with people as far as Oklahoma. It doesn't matter where you're from or what you need, we can still do something, we can still talk, we can still find resources, we can still be there for you. What matters is that if you need help with anything, you can be there.
Now, just shortly, the court's gonna go into recess, and when it does, we'll be able to come out there, we'll visit with you, I'll be handing this out to everyone, we'll pick up those documents from you as well, we'll answer any questions. And have it.
And one more thing before we go sit back down. I want you guys to know that we're not trying to add stress of any kind. That includes financial stress, any resource we set you up with is either gonna be state funding or the sliding fee scale. So if you need something and money doesn't really issue to finding it, talk to us. We're also state funded, we don't cost anything, we're just here to help. We're just here to do whatever we can. I understand this is a stressful moment and we want to be there to make sure that you're not outside of it. Usually a little bit more open and a little bit kids, I apologize you guys. However, we're gonna be up there if you guys need anything, or if anyone start feeling anxious. One of us can come down and talk to you, or in the recesses, we can go back and do that. You just let us know that. This is the only thing we're here for.
Thank you very much, thank you, Your Honor.
Okay, thank you, Deputy Hinton, Chris, and Chloe. Now, ladies and gentlemen, as I mentioned to you earlier, we're going to go into recess. If you need to use the restrooms, the two restrooms are out in the hallway. And if you need any assistance, we have our core personnel who is here and ready to assist you. So at this time, we're going to go into recess. And those of you who need assistance, just please raise your right hand. And we're going to have someone coming out there and picking up the paperwork from you. Court is in recess. Jefferson County, Florida, law number 2 is back in session. The court is in session in cause number 23 CCCR 0016. Case is styled the state of Texas versus Paulette Renee Haywood. Ms. Haywood, is that your full name?
Yes, sir.
Ms. Haywood, would you please raise your right hand? Ms. Haywood, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Haywood, you may put your hand down. How are you doing, Ms. Haywood?
I'm good, thank you. How are you?
I'm doing fine, thanks for asking, Ms. Haywood. You're represented in your case by your attorney, Laura Perazzo. Attorney Perazzo, how are you doing?
I'm doing well, Your Honor, thank you.
You're welcome. And state is represented in this case by Attorney Andrew Hubel. Attorney Hubel, how are you doing?
Doing well, Judge, and yourself?
I'm doing fine, thanks for asking. Ms. Perazzo, do you waive the record in Ms. Haywood's case?
Yes, Your Honor.
Ms. Haywood, I have before me a document that is titled information. This document is on my computer. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Paulette R. Haywood, on or about October 1st of 2022, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of possession of a dangerous drug. Ms. Haywood, do you understand what you have been charged with?
Yes.
To this charge, how do you plead? Guilty, not guilty, no contest?
No contest.
Are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes.
Ms. Haywood, also have before me a document that is titled Misdemeanor Plea Admonishments, which is also states Exhibit number 1. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there are a set of initials on the line next to the box that's check nolo contendere, which means no contest. The initials are PH. Did you place your initials on this document?
Yes, sir.
On the next page of the same document, there's a signature above the line that is titled Defendant. Ms. Haywood, do you recognize, is this your signature?
Yes, sir.
And on the next document, that's titled Trial Court Certification of Defendant's Right of Appeal. Ms. Haywood, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes.
Second box that's checked states that you're waiving your right to an appeal, which means you're giving up the right to an appeal. Do you understand that statement?
Yes, sir.
I also have before me a document on paper that is titled Discovery Certification. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
Ms. Haywood, before you signed and initialed these documents, did your attorney go over these documents with you?
Yes, sir.
And did you read and understand everything your attorney went over?
Yes, I did.
Is everything in these documents true and correct
Yes,
to the
sir.
best of your knowledge? Ms. Haywood, are you a citizen of the United States?
Yes.
Stay up for stakes 1.
Any
No
objections?
objection.
No objections. States Exhibit number 1 will be admitted. Ms. Perazzo, you advising counsel, Ms. Haywood, is there any evidence that she is currently mentally incompetent to stand trial?
No, Your Honor.
Ms. Haywood, your attorney, Ms. Perazzo, has advised and counseled you. Are you satisfied with her representation?
Yes, sir.
Has she provided full, effective, and competent legal representation?
Very much so.
Ms. Haywood, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is that agreement?
For defendant's plea of no contest, the state has offered 1 year deferred probation with a $300 fine and 40 hours community service.
That's correct, Your Honor.
Okay. What is the court cost? 277. Copy of her affidavit in this. Thank you. Ms. Haywood, the state is offering that you serve 1 year deferred adjudicated probation. During the 1 year probationary period, you'll be required to pay is there $100 fee?
Yes.
No, okay. You'll be required to pay a fine of $300 plus court costs of $277. You will also be required to pay a drug lab fee of $100. You'll be required to pay a probation fee of $6 a month, United fee of $15 a month, reimbursement fee of $15, and you'll be required to reimburse Jefferson County Court appointed attorney's fees of $250. Your total monthly installments, that is the total amount that you'll be required to pay each month while you're on probation, is $167 a month. Will you be able to pay the $167 each month? Okay, let's see. Ms. Haywood, I'm handing your attorney a document that is titled Affidavit of Indigence. Do you recognize that document? On page 2 of that document, there's a signature above the line that is titled Defendant Signature. Do you see that? Is that your signature? Is that on page 2?
It is not.
Let me see. Okay. She is signed, okay. The judge approved it. Cooperative. Okay. I see here, big stamp.
Oh,
She's on
okay.
cooperative.
I did not see that.
Okay, now, Ms. Haywood, you recognize the document?
Okay.
Is everything on that document true and correct?
Yeah.
And is it still current?
Governmentally.
Let me see.
Yeah.
Okay. Okay. Miss Haywood. State is offering that you serve 1 year deferred adjudicated probation during the 1 year probationary period. You are required to pay a fine of $300 plus court costs of $277, which comes to a total of fine and court costs of $577. The fine and court costs of $577 will be converted to 46 hours of community service. You also required to pay attorney's fees of $250, but the attorney's fees are going to be waived, which means you won't have to pay it pursuant to Article 46.05 G-11. And you will be required to pay a crime lab fee of $100. The probation fee of $60 a month is going to be reduced to the statutory minimum of $25 a month. And you'll be required to pay the reimbursement fee and the urinalysis fee of $15 a month. Your total monthly installments will be $54 a month. Will you be able to pay the $54 each month?
Mhm.
Okay,
Yes, sir, I'm sorry.
you're welcome. Now, let's see, I did this. Now, 46 hours of community service that was converted from the fine and court costs will be in addition to the 40 hours of community service that you are required to do, which will come to a total of 86 hours of community service. Do you understand that?
Yes, sir.
Now, you will also be required to adhere to the other standard terms and condition of probation. And Ms. Haywood, do you understand the state's offer?
Yes, I do.
Do you think that the state's offer in your case is fair and just?
I do.
And do you accept the state's offer?
I do.
Ms. Haywood, I'll follow the plea bargaining agreement that you have entered into with the state. Ms. Haywood, this will conclude your case. You're gonna stand next to the bailiff in front of the court coordinator and follow his directions. Oh, well, just have a seat because she's gonna have to make some adjustments on the paperwork. I just thought.
Oh, yeah, okay. I do.
Yeah, just have a seat. She's gonna make some adjustments on the paperwork. Now, Ms. Barrazo, this is your only case. You're free to go,
Thank you.
and you have a blessed day. You're welcome. Thank you. Mr. Ibarra, could you put this back in the cabinet for me? That the battery is going down.
Yes, sir.
Yeah. Get it charged back up.
It's the one
Okay.
with tape on?
Yeah,
Oh, 'cause I
apparently
just-
it didn't
didn't
charge. Yeah. Okay, who else we have? Okay. Jefferson County Court at Law number 2 is back in session. The court is in session with its arraignment docket. When I call your name, please come before the bench. First case is cause number 24 CCCR 0774, case of style of state of Texas versus Randy Johnson. Oh, Mr. Johnson, go back to your seat. They're not allowed to have shorts in the courtroom. Next case is cause number, well, two cases. Cause numbers 23 CCCR 2506 and cause number 24 CCCR 1016. Both cases are style of state of Texas versus Darrell Sam. Mr. Sam, would you please come forward? Mr. Sam, your full name is Darrell Wayne Sam, Darrell W. Sam. Mr. Sam, would you please raise your right hand? Sam, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Sam, you may put your hand down. How are you doing, Mr. Sam? That's good, Mr. Sam. I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? And is this your signature on the line that's titled Defendant? Are these your initials on the line that state you would like to apply for a court-appointed attorney? I have another document before me. This document is titled Jefferson County Affidavit of Indigence. Do you recognize this document? On page 2 of this same document, there's a signature above the line that is titled Defendant Signature. Is this your signature? Okay, now, Mr. Sam, before you signed and initial these documents, did you read the documents? Okay, you say you glanced over it. Okay, now this is the document.
I read that one.
Okay, now this one is the financial affidavit. Okay, on this document, on page 1, it has your name, R.W. Sam. It has your address, your date of birth, phone number. It has whether or not you were employed. So did you understand these questions up here? At the bottom of this document, it has some financial information, actually what your monthly assets are. Did you read this? And over here, it asks what your monthly expenses were. Did you read this? Okay, on page 2 of this document, it has a defendant's oath. Okay, and it says that on this 18th day of June, because you filled it out, June 2024, I have been advised of my right to representation by counsel, which is an attorney, in connection with the charge pending against me. I certify that I am without means of to employ counsel of my own choosing. And I hereby I hereby request the court to appoint counsel for me. Did you read that? And is this your signature and on this document? At the bottom of this document, it has your name, date of birth, your address, and Jefferson County, Texas, on the 18th day of June. And did you read this portion? Now, is everything in these documents true and correct to the best of your knowledge? Now, Mr. Sam, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. The attorney that will be appointed to represent you in your cases is Attorney Thomas Burbank. Attorney Burbank will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go. And you have a blessed day. Please have a seat in that first chair on the wall. Next case is cause number 24-CCCR-0340. Case is style State of Texas versus Antonio Estrada. Mr. Estrada, your full name is Antonio Estrada? How are you doing, Mr. Estrada?
Good.
Mr. Estrada, would you please raise your right hand? Mr. Estrada, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Estrada, you may put your hand down. Mr. Estrada, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendant Without Attorney. Recognize this document? Is this your signature on the line that's titled Defendant?
Yeah.
Or are these your initials on the line that state you'd like to apply for a court-appointed attorney?
Yes.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yeah.
On page 2 of this same document, there's a signature above the line that is titled Defendant's Signature. Is this your signature?
Yeah.
Mr. Estrada, before you sign and initial these documents, did you read the documents? Did you understand what you read?
Yes, I think I did have a question.
Okay.
It's like, so I was interested in the first time offending program, like the pre-trial one, please.
Right. You can talk to your attorney about that.
Okay,
Now, is everything in these documents true and correct to the best of your knowledge?
Yeah.
Okay, now, Mr. Estrada, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. Attorney that will be appointed to represent you in this case is Attorney Giles Cole. Giles Cole will be given information to contact you. You will also be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. And as I mentioned earlier, if you're interested in the pretrial diversion program, you can mention that to your attorney, so your attorney can assist you with the application that you need to file with the district attorney's office. Okay, just have a seat in that fourth chair on the wall. Andreana Coy. Ms. Coy,
Yes, sir.
your full name is Andreana Coy.
Yes, sir.
Ms. Coy, would you please raise your right hand? Ms. Coy, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Coy, you may put your hand down. How are you doing, Ms. Coy?
I'm finding
I'm doing fine. Thanks for asking, Ms. Coy. I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that titled Defendant?
Yes, sir.
And are these your initials on the line that state you'd like to apply for
Yes.
court-appointed attorney?
What,
Also,
can I ask a question? The case is old and I had went to arraignment, so I'm not sure if I had an attorney or not. I just filled out the paper.
well, you don't have an attorney. If you had an attorney, the attorney's name would appear on the docket sheet.
Okay.
Okay. Now, Ms. Cody, I also have a document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a signature above the line that is titled Defendant's Signature. Is this your signature?
Yes, sir.
And on the next, now, Ms. Coheed,
Mhm.
before you sign and initial these documents that I just showed you, did you read the documents?
Yes, sir.
Did you understand what you read?
Semi.
Okay, what you mean, a semi? Okay, let's go over the documents.
Like, for example, with the thing with the lawyer,
Okay,
I wasn't for sure if I had one or not. Like, the charge happened while I was incarcerated. And then I went to arraignment and they asked me and I told them, yeah, but then I got out. So I'm not sure if I have a lawyer.
well, once you got out, you wasn't appointed an attorney. That's when you come to the arraignment,
Mhm.
then we go over the process of seeing whether or not you want an attorney and see if you qualify for a court-appointed attorney.
Okay.
And so this is the process.
Yes, sir.
So you did not have an attorney. If you would have had an attorney appointed, the name of that attorney would have appeared on this docket sheet under attorney.
Okay,
And
so
so
by me, bonding out, I didn't meet the attorney.
apparently you bonded out before the attorney was appointed.
Okay.
Okay. Now, Ms. Coheed,
Yes, sir.
also, now before you sign and initial these documents, again, I'm gonna go, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your
Yes,
knowledge? Ms. Coheed, I read your answers.
Mhm.
Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in your case is Attorney Peter Doyle. Attorney Doyle will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information.
Okay.
Now, before the court coordinator gives you that information, I need to go give you some bond conditions. The bailiff is going to hand you a document that is titled Standard Bond Conditions in County Court at Law Number 2. Do you see that title?
Yes, sir.
I'm going to go over these bond conditions with you, and it states as follows. Following the return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who, A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yes, sir.
Condition number 4 does not apply, however, condition number 5 does apply. And it states, defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that
Yes,
condition?
sir.
Now, Ms. Cohey, if you violate any one of these bond conditions, your bond can be revoked. And if your bond is revoked, the warrant shall be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand?
Yes, sir.
Okay. Now, Ms. Cohey, this will conclude your case. You're going to have a seat in that first chair.
Mhm.
And when your name is called, you're gonna go to the court coordinator's window.
Yes, sir.
And once you finish at a window, you're free to go in your blessed state.
You too, sir.
Thank you. Next case, or the next two cases, well, the next case is cause number 24 CC Ciara 0780, case of style of state of Texas versus Brandon Lamont Darcy. Mr. Darcy, your full name is Brandon Lamont Darcy? Lamonte? Okay, Mr. Darcy, would you please raise your right hand? Mr. Darcy, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Darcy, you may put your hand down. How are you doing, Mr. Darcy? That's good. Now, Mr. Darcy, I have before me two documents. The first document is titled Judge's Explanation of Rights of Defendants Without Attorney. Do you recognize this document? Is this your signature on the line that's titled Defendant? Or are these your initial state that's on the line that states you would like to apply for a court-appointed attorney? And I also have another document that is titled Jefferson County Affidavit of Indigence. You recognize this document? On page 2 of this same document, there is a signature above the line that is titled Defendant Signature. Is this your signature? Mr. Darcy, before you signed and initial these documents that I just showed you, did you read the documents? You understand what you read? Everything in these documents true and correct to the best of your knowledge? Mr. Darcy, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. An attorney that will be appointed to represent you in your case is Attorney Mark Faggart. Attorney Faggart will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once you get the information from the court coordinator, you'll be free to go, and you have a blessed day. Please have a seat in the first chair on the wall. Okay. Next case is cause number M331386, case of style of state of Texas versus Courtney R. Darcy. Mr. Darcy, your full name is Courtney R. Darcy. Mr. Darcy, would you please raise your right hand? Mr. Darcy, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Darcy, you may put your hand down. How are you doing, Mr. Darcy? That's good, Mr. Darcy. I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? Is this your signature on the line that's titled Defendant? Are these your initials on the line that state you'd like to apply for a court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? And on page 2 of this same document, there is a signature above the line that is titled Defendant Signature. Is this your signature? Mr. Darcy, before you signed and initialed these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Mr. Darcy, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you in this case is Attorney David Grove. Attorney Grove will be given information to contact you, and you will also be given information to contact him. Our court coordinator will give you that information. And once she gives you that information, you'll be free to go and you have a blessed day. Have a seat in that third chair on the wall. Next case is cause number 23CCCR 1642. Case of style of state of Texas versus Jasmine Taft. Ms. Taft, your full name is that Jasmine Sheree Taft?
Yeah, yes, sir.
Ms. Taft, would you please raise your right hand? Ms. Taft, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yeah.
Ms. Taft, you may put your hand down. How are you doing, Ms. Taft? I'm doing fine, thanks for asking. Ms. Taft, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yeah.
Is this your signature online as titled Defendant?
Yeah.
And are these your initials online that state you'd like to apply for court-appointed attorney?
Yes.
Also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yeah.
On page 2 of this same document, there is a signature above the line that is titled Defender Signature. Is this your signature?
Yes.
Ms. Taft, before you sign and initial these documents that I just showed you, did you read the documents?
Yes.
Did you understand what you read?
Yes.
Is everything in these documents true and correct to the best of your knowledge?
Yes.
Ms. Taft, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of court-appointed attorney, and the attorney that will be appointed to represent you in this case is Attorney Benjamin Jeffries. Attorney Jeffries will be given permission to contact you, and you will also be given permission to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Please have a seat in that first chair on the wall. Thank you. Next case is cause number 24CCCR 0762. Case is style the state of Texas versus Zanaya Daniels. Ms. Daniels, your full name is Zanaya Daniels?
Yes, sir.
Ms. Daniels, would you please raise your right hand? Ms. Daniels, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to every God?
Yes, sir.
Ms. Daniels, you may put your hand down. How are you doing, Ms. Daniels?
Great, how are you?
I'm doing fine. Thanks for asking, Ms. Daniels. I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature online inside of defendant?
Yes, sir.
Or are these your initials online that state you'd like to apply for court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of the same document, there's a signature above the line that is titled Defender Signature. Is this your signature?
Yes, sir.
Ms. Daniels, before you sign and initial these documents that I just showed you, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Ms. Daniels, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Jack Lawrence. Attorney Lawrence will be given information to contact you, and you will also be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Please have a chair in that fifth chair or the fourth chair on the wall. You can move down to the third chair. Next case is cause number M329788, case style state of Texas versus Jonathan Thompson. Mr. Thompson, your full name is Jonathan Thompson.
Yes, sir.
Mr. Thompson, would you please raise your right hand? Ms. Thompson, Mr. Thompson, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
Mr. Thompson, you may put your hand down. How are you doing, Mr. Thompson? I'm doing fine, thanks for asking, Mr. Thompson. I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature online as titled Defendant?
Yes, sir.
And are these your initials online stating that you would like to waive your right to an attorney to represent yourself?
Yes, sir.
And Mr. Thompson, I also have a document that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. Do you recognize this document?
Yes, sir.
Mr. Thompson, is this your signature on the line as titled Defendant?
Yes, sir.
Now, Mr. Thompson, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Thompson, I read your answers. Have a seat and one of the prosecutors will come out and talk to you about your case. Next case is cause number 24CCCR 0774, case of style state of Texas versus Randy Johnson. Mr. Johnson, your full name is Randy James Johnson. Is that correct?
Yes.
Mr. Johnson, would you please raise your right hand? Johnson, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Johnson, you may put your hand down. How are you doing, Mr. Johnson? Okay, now, Mr. Johnson, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without an Attorney. You recognize this document? And is this your signature on the line that's titled Defendant? And are these your initials on the line that is titled, that states you'd like to apply for court-appointed attorney?
Yes.
I also have another document that is titled Jefferson County Affidavit of Indigence. You recognize this document? On page 2 of this same document, there are a set of, there's a signature above the line that is titled Defendant Signature. Is this your signature?
Yes, ma'am.
Now, Mr. Johnson, before you signed and initialed these documents, did you read the documents?
Yes, sir.
Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Johnson, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Don Boudreaux. Attorney Don Boudreaux will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Please have a seat in that first chair behind the wall. Court will be in recess. Jefferson County Court at Law number 2 is back in session. The court is in session in cause number 23 CCCR 0884. Case is style State of Texas versus Catherine Lachey Strange. Strange, would you please come forward? Miss Strange, how you pronounce your middle name? Lachey. Okay. So your full name is Catherine Lachey Strange.
Yes.
Is that correct? Ms. Strange, would you please raise your right hand? Ms. Strange, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Ms. Strange, you may put your hand out. How are you doing, Ms. Strange? That's good, Ms. Strange. I have before me a document that is titled Judge's Explanation of Right to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature online as cited defendant?
Yes, sir.
And are these your initials online that state you like to
Yes, sir.
reset your case to hire your own attorney?
Yes.
Now, Ms. Strange, before you sign any initial, this document, did you read the document?
Yes, sir.
Did you understand what you read?
Yes,
Is everything in this document true and correct
yes.
to the best of your knowledge? Okay, Ms. Strange, your case is going to be reset. Have a seat in that first chair on the wall. No, well, just go to the end of the counter and the court coordinator will give you a reset. Once you get your reset, you're free to go and you have the best day.
Thank you.
You're welcome. Here you go.
Okay, I sent you.
Burbank, okay. Okay, Mr. Burbank. Is this Stewart? Oh, I need a tablet. My tablet had red. You can give it back. It should be charged back up. It's in the cabinet.
Another one in here.
No, just get the same one I had. It should be charged up.
Huh?
I don't know whose tablet this is. No. Kindles. Take one. Next case is called number 24 CCCR 0106. Case is style of the state of Texas versus Kendall Stewart. Stewart, would you please come forward with your attorney? Mr. Stewart, your full name is Kendall Stewart. Stewart, would you please raise your right hand? Mr. Stewart, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Stewart, you may put your hand down. How are you doing, Mr. Stewart? That's good. I'm doing fine. Thanks for asking. Now, Mr. Stewart, you're represented in your case by your attorney, Attorney Tom Burbank. Attorney Burbank, how are you doing?
Doing fine, Your Honor.
And Mr. Burbank, do you waive a record in Mr. Stewart's case?
We do.
State is represented in this case by Attorney Andrew Hubel. Attorney Hubel, how are you doing?
Still doing well, Judge. Thank you.
It's good. Mr. Stewart, I have before me a document that is titled Information Sheet. This information sheet was filed by the Jefferson County District Attorney's Office. In this information sheet, Mr. Stewart, it alleges that you, Kendall Stewart, on or about November 18th of 2023, while you were in Jefferson County, Texas, that you committed to Class A misdemeanor offense of assault causing bodily injury and family violence. Do you understand what you've been charged with?
Yes, sir.
And to discharge Mr. Stewart, how do you plead guilty, not guilty, or no contest? No contest?
No,
Now, are you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges? Mr. Stewart, I also have before me a document that is titled Jefferson County, well, it's titled Misdemeanor Plea Admonishment. This is also labeled as State's Exhibit Number 1. Do you recognize this document?
yes, sir.
On page 2 of this same document, there are a set of initials on a line next to the box that says check nola contendere. Actually, it's 2 sets of initials. One set is your attorney initials. The other set of initials, KS. Did you place your initials on this document?
Yes, sir.
On page 3 of the same document, there's a signature above the line that is titled defendant. Is this your signature? And on the next document that is titled trial court certification of defendant's right of appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes,
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? I also have before me a document that is titled Discovery Certification. Do you recognize this document?
yes, sir.
And is this your signature on the line that's titled defendant? Mr. Stewart, before you signed and initialed all of these documents that I just showed you, did your attorney go over these documents with you?
Yes, sir.
And did you read and understand everything that your attorney went over?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Stewart, are you a citizen of the United States?
Yes, sir.
Step for stage 1.
Any objections?
No objection, states one.
No objection. State's Exhibit Number 1 will be admitted. Mr. Burbank, you've advised and counsel, Mr. Stewart, is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
And Mr. Stewart, your attorney, Mr. Burbank has advised and counseled you. Are you satisfied with his representation? Has he provided full, effective, and competent legal representation?
Yes, sir.
Okay, Mr. Stewart, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
What is the agreement?
For defendant's plea, the state is over 55 days time served, court calls tax and retired.
Okay, Mr. Stewart, the state is offering that you serve 55 days in the Jefferson County Jail. However, you do not have to serve any more time in the Jefferson County Jail in this case because you've already served 55 days in Jefferson County Jail. Therefore, you'll be given credit for the time that you've already served. What is it? Court cost? Okay, and the court cost in this case is $277. However, you will not be required to pay the court cost because the time that you spent in jail has already paid off the court cost. Therefore, the court cost will be taxed and retired. Mr. Stewart, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Okay, Mr. Stewart, this will conclude your case. Please stand in front of our court coordinator, follow the directions of the bailiff. Once you finish following his directions, you'll be free to go and you have a blessed day. And Mr. Burbank, you're also free to go and you have a blessed day as well.
Thank you, Your Honor.
You're welcome. Jefferson County Court at Law number 2 is back in session. The court is in session and calls number M329-788. The case is styled the State of Texas versus Jonathan Thompson. Mr. Thompson, is that your full name?
Yes, sir.
Mr. Thompson, would you please raise your right hand? Mr. Thompson, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Thompson, you may put your hand down. How are you doing, Mr. Thompson? I'm doing fine. Thanks for asking. Mr. Thompson, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line as titled defendant?
Yes, sir.
Or these initials on the line state you want to waive your right to an attorney
Yes,
and
sir.
represent yourself? I also have another document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Mr. Thompson, before you sign and initial these documents, did you read the documents? Did you understand what you read? Is everything in these documents true and correct to the best of your knowledge? Mr. Thompson, I also have before me a document on my computer that is titled Information. This information was filed by the Jefferson County District Attorney's Office. Now, before we go any further, Mr. Thompson, you have a right to have a court reporter to dictate everything that's being said in this case, and you also have a right to waive or give up your right to have a court reporter. Do you waive or give up your right to have a court reporter?
Yes, sir.
Okay. Now, Mr. Thompson, I also have before me, as I mentioned earlier, a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Jonathan Thompson, on or about April 2nd of 2021, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of possession of a controlled substance, penalty group 2A. Mr. Thompson, do you understand what you've been charged with?
Yes, sir.
And to this charge, Mr. Thompson, how do you plead? Guilty, not guilty, or no contest?
Guilty.
Now, you're pleading guilty freely and voluntarily,
Yes, sir.
and are you pleading guilty because you are guilty?
Yes, sir.
Okay. Before you have the other gentleman to go back, I need to bring him back out and I just have to read a admonishment to him. Okay. Now, Mr. Thompson, I also have before me a document. Well, actually, you understand what you've been charged with, right?
Yes, sir.
And to this charge, how do you plead?
Guilty.
And are you pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you are guilty?
Yes, sir.
Mr. Thompson, also have before me on my tablet a document that is titled Misdemeanor Plea Admonishment. This document is also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, sir.
On page 2 of the same document, there's a set of initials on the line. Well, two sets of initials. First set of initials is on the line next to the box that's checked guilty. Did you place your initials on this line, JT?
Yes, sir.
And the second set of initials is on a line, but it's below a paragraph that is titled Discovery, Admonishment, and it states, I do not request discovery of the evidence. I waive my right to request discovery in this case and choose to enter a plea of guilty and no contest. Did you place your initials on this document?
Yes, sir.
On page 3 of the same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document? And is this your signature on the line that's titled Defendant?
Yes, sir.
At the top of this document, there are two boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
Now, Mr. Thompson, before you sign and initial all of these documents that I just showed you, did you read the documents? Did you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Thompson, I read you. Mr. Thompson, are you a citizen of the United States?
Yes, sir.
Stay up for stage 1.
Mr. Thompson, the state is offering State's Exhibit Number 1 to be used as evidence in your case. State's Exhibit Number 1 is the document, first document that shows you on the tablet that you recognize, and it's also the document that have your initials on the two locations and your signature on page 3. The state would like to use this document as evidence in your case. Is it all right for the state to use this document as evidence in your case?
Yes, sir.
Okay, no objection states exhibit number 1 will be admitted. Mr. Thompson, is there any evidence that you are currently mentally incompetent to stand trial? Okay, Mr. Thompson, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
State, for defendant's plea, state is offered 14 days time served for cost action retired in this case.
Okay. Mr. Thompson, states offering that you serve 14 days in Jefferson County Jail. However, you will not be required to serve any more time in the Jefferson County Jail in this case because you've already served 14 days in Jefferson County Jail. Therefore, you'll be given credit for the time that you've already served. The court costs in this case will be taxed and retired. That simply means that you will not be required to pay the court costs because the time that you spent in jail has already paid it off. Therefore, the court costs will be taxed and retired. Mr. Thompson, do you understand the state's offer?
Yes, sir.
You think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Mr. Thompson, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Thompson, you're gonna stand in front of our court coordinator and follow the directions of the bailiff. Once you finish following the directions of the bailiff, you'll be free to go, and you have a blessed day.
Thank you, sir. You too.
You are. Okay. Now, Mr. Stewart, would you please come back? Would you come up? Mr. Stewart, I need to give you a admonition. Could you please hand this here to Mr. Stewart? Mr. Stewart, I need to get this to you. Your case was disposed of. Your case was assault, family violence. And so I need to give you the written admonition on ineligibility to possess a firearm or ammunition in accordance with the Texas Administrative Code, section 176.1. The court hereby admonishes you or warns you of the following. Number 1, you are by entry of order or judgment ineligible under Texas law to possess a firearm or ammunition. Beginning now. That's number 2. Beginning now, if you possess a firearm or ammunition, it could lead to charges against you. If you have questions about how long you will be ineligible to possess a firearm or ammunition, you should consult an attorney. Number 3, under Texas Penal Code section 46.013A, firearms mean any device designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion or burning substance, or any device readily convertible to that use. B, firearm does not include a firearm that may have as an integral part a folding knife blade or other characteristics of weapons made illegal by Penal Code Chapter 46, and that is 1, an antique or curio firearm manufactured before 1899, or 2, a replica of an antique or curio firearm manufactured before 1899, but only if the replica does not use rimfire or centerfire ammunition. The statutes listed below are a starting point for ineligibility to possess a firearm or ammunition. For more information about the laws that make you ineligible to possess a firearm or ammunition, or for more information on how long your ineligibility to possess a firearm or ammunition lasts, the court recommends you contact an attorney. Code of Criminal Procedure Article 17.292, Magistrate's Orders for Emergency Protection. Code of Criminal Procedure Article 42.0131, Notice for persons convicted of misdemeanors involving family violence. Penal Code Section 46.02, unlawful carrying weapons. Penal Code Section 46.04, unlawful possession of a firearm. Penal Code Section 25.07, violation of certain court orders or conditions of bond in a family violence, child abuse and neglect, sexual assault or abuse, indecent assault, stalking, or trafficking case. Family Code Section 85.06, warning on protective orders. Now, Mr. Stewart, the written admonition that was given to you is for your records. You can follow the bailiff, and you have a blessed day. Thank you. Okay. This one. Okay. Jefferson County Code Law number 2 is back in session. The court is in session in 2 cases, cause numbers M329144 and cause number M329146. Both cases are styled of state of Texas versus Joshua James Smith. Joshua James Smith was scheduled to be in court this morning at 9 a.m. At or about 9 a.m. The court's bailiff called the name of Joshua Smith at the courthouse door. Joshua Smith did not answer. Joshua Smith has not appeared in court since the court has been in session. The time now is 11:59 a.m. on today's date of June 18, 2024. Mr. Bailiff, could you please call the name of Joshua Smith at the courthouse door? Okay, Joshua Smith's name was just called at the courthouse door. Joshua Smith did not answer. A reasonable time has passed to give Mr. Smith an opportunity to appear in court. State, do you have a motion?
Single for bond forfeiture.
The motion will be granted in each case. Joshua Smith's bond will be forfeited and a warrant should be issued for his arrest and cause numbers M329144 and cause number M329146. The court will be in recess until our trial. Our court will be in recess until our trial start back up at 1:30 this afternoon.